Hello, welcome to the 7-set video series of critical issues for purchasers of residential properties to be aware of in relation to building and pest matters. My name is Ryan Craig. I'm the owner and consultant for QC's Building Services, licensed in both building and pest areas for property inspections, and have been doing this work for around 20 years in the Brisbane and Greater Brisbane area, which basically my experiences in this field has driven me to the point where I've decided to make this set of videos, 7 in total, to educate buyers of residential property about some fundamental issues that, from what I see on a daily basis and have done for a long time, they're just not aware of, and it can be very costly for them. It can be an emotional toll. They can be buying properties that are not what they think they are. A lot of things that can affect them that I think in this 7-set series people need to know, and that will assist them in minimizing the risks of that. So the 7 videos, basically the first video is all about the manner in which properties are not marketed correctly and truthfully to the general public. Our experiences show about 50% of residential properties for sale, when further testing is done and actual formal searches of the nature in which it was marketed are carried out, our clients are told that 50% of the time that it's not actually what it is marketed as, and it's completely different on the council records. And it's quite astounding when you think 50% of properties for sale are of that nature. Well, certainly the 50% of the properties we see. The second video will be about different service levels for building and pest providers. Critical that you know about this, because there's a huge difference between the companies that are out there and what type of information you're going to get, the amount of information that a building and pest inspection company will give you, and the manner in which it's provided. Is it going to be generic tick and flick, or comprehensively written digital photography, maybe video of the defects? There's a big difference out there, so you need to be aware of those two, and that'll be covered in video 2. Number 3 will be about the issues relating to a more commonly carried out practice, which is where vendors are now providing building and pest reports to prospective purchasers, and there'll be some good information in the number 3 video about that. Number 4, great information about contract issues and relevant searches that we think you should be doing based on building and pest matters for potential property purchase. Number 5 is about the importance of getting the right time allocation for the building and pest clause on the contract, and that'll be number 5. Number 6 is a video all about verbal advice, which is commonly thrown at purchasers, but really based on what we see when it's tested, and is it factual. There's a huge amount of time where what was said is a distant far cry from the reality of the matter. So we'll cover that in item 6 about verbal advice being given to you, how to deal with it, and how to ensure you don't fall victim to some false information that's given to you. Lastly, and just as importantly, is a video which will be all about the importance of you making a formal written request of the vendor to disclose any known building and pest issues. Now, there's no obligation on a seller of a property to disclose to you a known issue that they might have about the property as part of the sale process. In fact, there's actually, what we find is more of a concerted effort by vendors to conceal any known defects rather than disclose them, because when we do our inspections and maybe find a defect that we want to query the vendor about, they give us answers which clearly show that they were aware of this but didn't tell the purchaser. So one way you can get around that is by making sure that you make a formal request for any disclosure, and we'll cover that in item 7. This video, however, is all about familiarising yourself with the contract that is the most predominant contract used for the purchase and sale of residential property, what terms are in there and how they are affecting purchases, and also a very important legal search that should be done as part of your due diligence about the property in question, which is often not done, but we'll explain the critical importance of that a bit later in this video. So, first thing we'll start off with is the contract that is predominantly used in amongst the industry for real estate is one that is astoundingly designed by half designed by an organisation called the REIQ. So, the REIQ is the acronym for the Real Estate Institute of Queensland, who represent all of the real estate agents within Queensland. So it would stand to reason that if they were responsible for the generation of a document that is used for the purchase and sale of a residential property, then it's probably going to have clauses in there that are going to be more favourable to the vendor and sort of slighted towards the agent, dare I say it, in terms of the nature of the clauses and the manner in which it is not to the best interest of the purchaser. And certainly from a building and pest point of view, that's absolutely correct, and I'll cover that now. So be aware of the first thing is the contract that you use is designed by the very organisation that controls and looks after real estate institutes, and they obviously, the real estate agent is working for the vendor, and their interests are not necessarily your best interest as a purchaser. So that's how it starts off on that nature. The very contract you sign is designed by an entity that is not representing you and has biased interest, let's say. What I mean by that is there's several unfavourable clauses talking about the building and pest, but there's other ones in there that you need to go through with your conveyancing solicitor that are not of the building and pest nature. But let's cover the building and pest. So the first one is that within the standard REIQ contract, in the event that a purchaser organises for a building and pest inspection and raises an issue, let's say about a retaining wall or something that they're not quite happy with that they'd like to discuss or bring up, under the terms of the contract that you've signed, the vendor is therefore entitled to immediately request of you, the purchaser, full copies of both reports for the building and pest that you've had carried out. One would think that if you're raising one issue, that you probably should only have to provide the information about that issue. However, that's not the case, and that's not what's stipulated in the contract. You're to provide the vendor legally a copy of both reports in the event you raise anything and you're not satisfied with the building and pest. So the next part which is linked into this is in the same area of the contract. There's a stipulation or a clause which says there's two key components to the way you must act as a purchaser in relation to the building and pest. One is you're to act reasonably. When I say that is you're entitled to get building and pest reports, and the two key words are that you must act reasonably and you must be satisfied or not satisfied with the findings of the building and pest. So I'll give you a scenario that could potentially hurt you or leave you vulnerable if you signed that contract and didn't make any amendments. Number one is the fact that the vendor will get a copy of the report which you've paid for. It's your property, so they have a copy, and in a lot of cases we've actually seen, should a purchaser not go ahead with the property, full reports that have been provided to a client of ours that have not necessarily purchased the property in question, who have moved on for whatever reason, are then given by agents to new prospective purchasers because it suits the agent even though it's not their property and it hasn't been paid for. So that's one aspect that's always been a bit of an issue for us in terms of receiving calls from people we don't know who are not our client, not the client we've used, and finding out that the agents are passing out the property of other clients of ours. So anyway, that's one aspect. But it also, in the case where it was involving you and you were going to pull out, it would give the vendors a formal record of all the information in the two reports. Now, the next aspect is satisfied. Now, if you say you're not satisfied under the terms of the contract, you can pull out. But you are to act reasonably. Now, this is the big one. We've seen this over the years where if a vendor, who defines reasonably? So you might say to your conveyancing solicitor, I don't want to purchase this property. I want to pull out because I'm not satisfied with the building and pest, and you think I'm acting completely reasonably. That's all very well until your solicitor goes to the conveyancer for the seller and says, my client doesn't want to go ahead, they're not satisfied with the building and pest, and they don't even say they're acting reasonably, and they give you the reason and the basis that you want to pull out. So because of the nature of the wording of the contract, what you're doing is giving a potential vendor the opportunity to debate with you how reasonable you're being on an issue. So because of the format of it, there's a platform there for a vendor to potentially say, I'm not going to refund your $50,000 and I'm not going to allow you to not proceed with the purchase of this property because in my opinion, I don't think you're acting reasonably with your reasons for pulling out about the building and pest, and therefore it's going to be contested, which can happen. It really can, because of the way the contract's set up. You can eliminate that, however, by manipulating the contract and taking the clauses out, i.e. don't have the clause in there which says for the building and pest that the vendor can obtain a copy of both reports. Scratch that out. It's not their property, it's up to you. You've paid for them, it's your information. Secondly, take out the part where it says that you're to act satisfied. Simple, you just strike through it. You eliminate it as part of your offer to the vendor, and therefore it's not relevant to the contract in its format that it was before you submit it. So If there's no debate about being reasonable, if you've taken that out, and if it just simply says you're entitled to get 2 building and pest reports, and if you're not satisfied with those findings, you don't have to give the copies of the reports anymore to the vendor because you've taken that out, and there's no reference to the term you are to act reasonably, then you've got far more safeguard and protection to pull out without any potential of being linked into a vendor that's desperate for a sale that may see an opportunity to try and hold you to a contract that could cause you money, distress, and hold you into time. So a couple of small changes in the contract in relation to the building and pest will give far more protection, as I've just shown there, for a purchaser. The way it is now, big problems, favoured for the vendor, and it doesn't look after the interest of a purchaser. So always get legal advice about the contract you're going to enter into for the purchase and sale of the property. One, because it's designed by the organisation that represents the seller. So it is biased, and I've given you 2 examples of that with just the building and pest clauses and the terms in there, but there are others. And you should go to a solicitor before you give your contract, have it amended so that it suits you, and that's your offer to the vendor. What happens at the moment is people put in offers for residential properties based on going to an open home and then going to the agent's office, or the agent having a contract, which is the full format contract, putting it in front of a purchaser. They fill it out none the wiser because they're not educated, and it's got clauses like this in there which entraps them basically, or leaves them open for scrutiny and doesn't protect their best interests. One other thing we recommend you do that can often get lost in the purchase of a property is, a lot of the times properties are bought, there's been recent construction work or some sort of rectification done for leaks or something like that, and warranties might be applicable for that work. They would be in the vendor's name, obviously, because you weren't the owner of the property at the time they were done, and they may still be current for a period of time or years. Or solar panels might have been insisted, they have a 5-year warranty, but it's in the vendor's name. Or any other appliance that's just recently been bought, air conditioning or some sort of thing like that. Often it will get missed in the legal side of the transfer and the title transfer from vendor to purchaser. These warranties will get missed. So make sure you dot your I's and cross your T's with making sure that it is in writing and it's formal, that any warranties that are currently applicable to the vendor for any work, construction work, appliances or anything of that nature are transferred to you and acknowledged so from the companies that have done the work, also provided these appliances, because as I say, it doesn't quite all the time get caught in the conveyancing or the legal side of it for the property. And if you don't do this, you could find yourself, if you bought a property, you moved in, 12 months down the track, you find that the brand new solar panel system that's on your roof with 20 panels stops working. You were told at the time you purchased the place, it's only been in a year, it's got a 5-year warranty. You think, okay, that's great. You ring the company and they say to you, sorry, there's no warranty here because you're not our client and we haven't transferred any warranty to you, and you could leave yourself open for that. Whereas if you did make sure it was done during the conveyancing and the legal side of the purchase, you're protecting yourself, safeguarding yourself. One thing that is really, really, really important that is not done all the time by a conveyancing person representing purchasers, and despite the fact of its critical nature, and refer video 1 about that with the incorrect manner in which properties are marketed, 50% of the time that is, our very strong advice to anyone purchasing a property, if it's irrelevant, it's brand new, existing, that's had additions, alterations that require formal approvals and certification under the legal statute law of Queensland, is that before you enter into a contract on a property, which is invariably based on the marketing information on realestate.com and other domain and all that, validate that it's true. You can only do that not by acting on and trusting information from the marketing agent, but by carrying out a formal search with the local council authority, because they're the organisation that have the records about the property and the characteristics of the property and can give you the truth about what is on record for the property you're looking at buying. Video number 1 will cover a lot more of this, but make sure your solicitor, the key point is really make sure your conveyancing solicitor is doing a search with the council authority, which will determine what the council authority have on their records for the property. Is it a 4-bed, 2-bath, that's the way it's been marketed? Or does the council have an incomplete building project there that had an application that didn't have a final inspection certificate? You must know about this before you put an offer in on a property, because as we said earlier, 50% of properties are not marketed correctly. Don't be one of those victims that put an offer in on a property based on the marketing information, incur costs on building and pest, incur costs on conveyances, incur time, emotion, all on something that's false, when you can simply eradicate that by making sure you do a search with the council find out the truth about the property, and then act in confidence with your offer because you know it's true. Okay, so I hope this video you found it informative and it's of some benefit to you in terms of your due diligence and in relation to a potential property purchase. Please pass this information and knowledge about these 7-set videos on to all of your friends and network that might be carrying out these kind of property purchases or doing this kind of thing in the near future, because the information is so critical and important to them, and it can save them potentially losing money, costs, and just be informed, and you can be in control of the situation, as opposed to currently where people aren't informed and they're vulnerable to being manipulated and making decisions that aren't based on truth, and that'll cost them money and stress. Please also visit our YouTube sites, QC's Building Services, and our website, www.qcsbuildingservices.com. Plenty of videos on there as well, all important information, not just about the purchase contract and building and pest issues there, but also information about what is building, lots of information about inspection services and what you should know, and as part of your knowledge, so that you can get the best service from a provider. Good luck with your house hunting and property hunting, and if we could be of any benefit or assistance to you in the future, we would love to help you out. Thank you.